show you the difference between a published patent application and a granted patent, because both they look pretty much the same if you don't know what to look for, but it's easy to tell the difference if you do. So one of the things you can see here, this one does say patent application publication, but importantly is because some of the older ones may not say that, you want to look at the number. You see the publication number. First of all, you'll see pub number and pub date. The important thing to know about the number is that it starts with a country code and then a year. But if you see a year, then you'll know that it is a patent application, because granted patents do not start with a year. All right, so here is this published application for a scope, and then if I go over here and show you, this is the granted patent from that application. So you'll see the difference. They look pretty much the same, but one of the big differences is, for one thing, if you notice, the application was published in 2017. This patent was granted in 2021. So that's 4 years later. That's not unusual. By the way, the patent applications are published 18 months after they're filed. And so the significance of that is that once the application is published, it is now public prior art. It can be found in patent searches all throughout the United States and actually throughout the world. And that can act as a block to prevent someone else from getting a patent on something that you have disclosed in your patent application once it's published. Before it's published, it's not published, so it cannot be found. It's still priority, it's still prior art, but it doesn't show up in prior art searches until it's published. So that's one of the big significances of patent publication, is that's one of the things that blocks others from getting patents on your invention. So then the application, that's the published application. Here you'll see the actual published patent. And so you see it doesn't start with a year. It's a country code followed by a number in the 10 millions. If they're older patents, they're in the millions. And you'll see, other than that, it looks very similar. So if you're not seeing a number that looks like this 10 million or whatever, if instead you're seeing something that looks like this with a year, then you're looking at an application, not a granted patent. Patent applications, they are important for prior art, as I just said, but they are not enforceable. So you can't take that to court and sue someone for patent infringement, because until the claims are granted, you don't actually have a patent. You just have a published application. Okay, so when you get something that looks like this, that's when you have a patent. All right, and then the next thing to do, once you confirm that it is an actual patent, not an application, the next thing to do is to check whether it's still in force. Patents need to be renewed or maintained, they call it, in order to stay in force. If you want to get that full 20 years in the United States, you need to pay 3 maintenance fees at 3.5, 7.5, and 11.5 years. If you don't pay one of those, the patent expires early. So that's important to recognize. If you had a patent granted a while back and you don't know if you've paid maintenance fees, check it out. So one of the things to do once you confirm it's a real patent is you confirm whether it's still in force. If it's not in force, it still acts as prior art to someone else, but it cannot be enforced against someone for infringement. Only a granted patent that is in force can be infringed. And then if you discover that it is a granted patent and it is in force, the next thing to do, so you may get distressed when you read all of it. You'll see there's all these drawings, and then there's some things at the end. There's more verbiage, there's lots of drawings, and you might see something that looks just like your thing in the drawings. But the drawings and all of this verbiage, let me see if I can get this to load, all of the verbiage up to this point is all very important, but it is not what is covered in the patent. So the coverage, what actually is enforceable patent rights, is just this part after what says what is claimed is. Just that highlight didn't work, but just these numbered paragraphs after the words what is claimed is, that is the boundaries of the granted patent. All the rest of it is not what's covered, it just illustrates what's covered. Usually the disclosure that comes before the claims is broader than what is actually covered in the claims. So that's the last piece of information I wanted to leave with you. I hope that was helpful. Catherine Cavella, IP Works Law.